This application is, in essence, an application on peace, security, and territorial integrity, but it is nonetheless couched as a human rights application. The core of it is an application. The issues therein concern issues that are dealt with directly under the Great Lakes Pact, and going by Article 28.1 of the Great Lakes Pact, wherein states undertake to settle all their disputes therein peacefully, we emphasize that this indeed is a bar to this application. As to the question of the court being or having a self-contained legal framework and why we refer to procedures of other courts, we would emphasize, Mr. Vice President, Honorable Justices, that the court is part of the international law family. And we refer to these other procedures from other judicial and quasi-judicial mechanisms, not to say that this court does not have its own rules, but so that the court can find inspiration in how these other mechanisms have dealt with an issue that this court is dealing with for the very first time. As to whether the ESCJ matter is a bar to this one, I would beg to take that with the question posed to us by Lady Justice Trafika on how does this abuse of process make this an inadmissibility issue. First, I would start by saying that Articles 56 and Rule 50 of the court do not provide an exhaustive list of admissibility requirements. Nonetheless, that said, we would not venture to say that the abuse of process is an absolute bar, legally speaking, to this court handling this particular application. Nonetheless, what we are saying is that the abusive nature of filing a case before this court and before the International Court of Justice calls for this court to endeavor to avoid the sort of judicial chaos and judicial embarrassment that would then result from entertaining this application while the ESCJ is also entertaining the application. And it does have inherent powers to do as we have proposed. And similarly, as we indicated in our submissions, other judicial and quasi-judicial mechanisms have taken a similar route for the integrity and harmony of the international legal system. Again, lastly, from Justice Gasagwa, what our opinion of Rule 64.2 would be, what our comment on it would be, and our comment is that, indeed, that rule applies if the parties agree. And that, I beg, is our very brief response to that particular question. Moving on to Justice Ajay, and thank you very much for your questions. The first question posed was why we expect the DRC to exhaust remedies. And to clarify, our submission was that the DRC, we are not saying that the DRC as a state should exhaust local remedies. The local remedies should be exhausted by the victims before then the DRC can take up their case on their behalf. If the victims are then unable to exhaust those local remedies, then the DRC as a state would take it up. And then as the reference to the European system and the inter-American system, yes, indeed, we acknowledge that Rule 50, paragraph 2E is couched in a slightly different manner by requiring that local remedies should be exhausted, if any. And our primary submission, and we have gone to great lengths to actually demonstrate that in this particular case, those local remedies do exist in Rwanda. So the if any part actually does apply in this case. They do exist. And Justice Anukam asked about specifically that we distinguish Communication 227/99, the DRC v. Rwanda and Uganda, paragraph 63, and our response would be, as we have also indicated in our written submissions, that that case is distinguishable because in that particular instance, there were 3 respondent states, Burundi, Rwanda, and Uganda. And based on that basis, it is our assumption that on that basis, the Commission made the pronouncement that it did make, which is distinguishable from this particular case where it is only one respondent state, which is Rwanda, and that we have, of course, gone to great lengths to demonstrate that within Rwanda it is possible, the local remedies are in existence, they exist, and accessing them is possible. There is absolutely no bar to anyone, national or otherwise, and despite their location, accessing those remedies. I believe I have responded to the question that I can. I would yield the floor with the kind permission of the Vice President to Lorraine.
Mr. Vice President, Honourable Justices, I am grateful to Honourable Justices Anukam and Shafika for their questions, and I will be brief in light of the time constraints. Honourable Judge, you are absolutely right. There are 75 annexes with the application, which is a mix of media and non-media sources. We accept, of course, that where some aspects are based on media sources, but there are some that are in support of the application which are not, then the case would be admissible in light of your jurisprudence. However, when Rule 52D talks about an application being inadmissible, it is talking about the present application that is before you. So in this case, the claim that is made against the respondent, against Rwanda. So we submit that there are two critical points in response to your question. The first is that the application seeks to engage the responsibility of Rwanda. It seeks to attribute conduct to Rwanda, and we submit that the non-media annexes referred to do not attribute the alleged conduct referred to in the application to Rwanda. They are directed to the general situation in the Eastern DRC, and therefore cannot support the case that is actually present before you. The second point is this. The non-media annexes, as you may have noticed, are largely outside the temporal scope of this application. If I may please direct your Honourable Justices to Section 4 of the application, which is where the summary of facts is contained, the DRC stated, and I quote, "The facts at the origin of this case date back to November 2021. So, Mr. Vice President, Honourable Justices, we are looking at events between November 2021 and 11th August 2023 when this application was filed. That is the temporal scope of the application before you. And so while there may be non-media annexes which deal with the situation, they cannot be taken into account, we respectfully submit, by this court when considering whether they support the application that has been brought and are therefore admissible. To be clear, and if I may take that opportunity, we are not challenging the credibility or quality of those sources. That is because we don't need to. What we are saying is that they do not go to the very case that is brought against Rwanda. They don't attribute the conduct complained of to Rwanda, and even if they do, they fall outside the temporal scope of the application that has been brought before you. Honourable Justices, I hope that answers your questions, but we are of course in your hands if it will be assistance to put a response in writing. I'm very grateful for your time. Thank you.
C'est bon, vous avez terminé? Merci beaucoup.
The applicant state your answers, please. Thank you, Honorable President. In the next 7 minutes, I'll answer 3 of your questions, and my colleague, Professor Ezekiel, will answer the other questions. The first question is for us to give you our reading of Rule 64.2 on amicable settlement. Yes, it's a possibility provided for in the rules of the court, but DRC does not intend to submit this matter for amicable settlement, and this for several reasons. The first one is that this is not the first time that the respondents are committing serious, grave, massive violations on our territory, and in a repeated matter. But how do you go and negotiate amicably with a party that since 2021-2022 has demonstrated its intentions. Secondly, the respondents and applicant have already participated in other negotiations on various aspects of this issue, and you recall the Rwanda process, which did not succeed because of the conduct of the respondent state. Another argument is the point made by the respondents in international system. If we subject this to the international system, we don't know what will happen. All the victims have the right to the truth. This was a case in the Ajavon case. The court came back to the issue, to the truth and reparation. The second question was on attempts of the respondent state, whether the applicant state tried to exhaust internal remedies. As I said in my presentation, the applicant state, for reasons that have been clearly explained, the respondent state cannot even attempt to exhaust internal remedies. You saw with Professor Ntumbala yesterday, there are thousands of victims. Many people have been directly and indirectly affected. And the very nature of these violations, if we recall November 2021, we have victims, and there were others in March 2022, 2023. So each time there are violations, we will have to go and exhaust. And we need to take into account the lives of the victims and the capacity of the victims themselves. Do they have, or the capacity of the applicant state itself? Do we have the capacity to deal with all these cases on its territory? And then also the troops of the respondents that are on the DRC territory. They not only are they in the areas where these victims are located, and how are these victims going to find justice where the perpetrators of the violations are located? You also realize with the communication to 2025-99, which clearly demonstrated that Rwanda has committed massive violations, and this since 2023, that this communication was rendered by the African Commission. No action has been taken by the respondent. And in my submission, I gave a list of persons that are sought by the Congolese judicial system and who have not been prosecuted. I believe with these explanations, there is no need to take the issue further. Let me conclude with the question posed by Justice Chafika Bensaoula on continuous violation and issue of whether it's a link to the admissibility. I must say that the issue of continuous violation relates to the temporal jurisdiction of the court to say whether an applicant talks about violations which occurred before the entry into force of the charter. The court will have jurisdiction only if the violation has a continuous nature. That is known. And the court will normally distinguish between continuous violation and instant violation. And if I refer to Akosi Boateng, in which Justice Chafika rendered a separate distinction, where she made the distinction between continuous violation And you'll see in our brief that there are certain violations that were certain violations before 2021. But there are others that are instant, but their effects are prolonged. But when does the issue of continuous violation have a link with admissibility? It is like in the case of this matter where there are a number of activities and a number of activities. The fact that we came before the court in 11 August 2023, there are other acts that continued. The respondent state army is still on the territory of the applicant state. So we can say that the acts violations are continuous and repeated. To conclude, I made reference to the jurisprudence of the European Court of Human Rights when it talked about administrative practice, and the European Court asserted that where certain violations are regular, repeated, tolerated, it means that it is an administrative practice tolerated by the respondent state in that matter. I believe I have answered the 3 questions that were put to the applicant, and with your kind permission, I'll call upon Professor Ezekiel to add on.
Honorable Vice President, Honorable Justices, like my colleague, I will try to respond to the questions raised by the court, especially Justice Ajay, Anuka, and Ben Saula. The first question with which I will start is to know if the amended application as filed to the East African Criminal Court is admissible. In fact, already this application has been filed. You will find this document under number 0102 of volume 5 of the documents appended in the file and the application, and which were shared with the parties. Now, the question to know whether we can list some documents which were appended to the application and which are not related to the mass media. I would like to refer to the application and its annex. In the annex of the list dependence application, you will find document 55, 57, 62, 65, and 67. This is as an example. And the selection of such documents was to reply to the fact that these documents which date back to a period before the filing of this application, and I would like to give you or to provide you with the titles of some documents which I have just quoted that date back to the date before the alleged date, where it is clearly indicated that it is the date that will determine your jurisdiction. For example, number 52 of the annex is entitled Midterm Report of the Expert Group on the DRC. It is a document of the Security Council entitled S0 2022-977 of 16 December 2022. Also, under number 54 and in addition to the other numbers I have quoted, documents from the Peace and Security Council of the United Nations that have examined these documents and which have noted a number of violations. Now, I would like to address and talk about the argument relating to this Ali dependence issue from Judge Ajay. Your question shows the difficulty of the position proposed or introduced by Rwanda. They want to extend the Rule 37 para 1 of your rule that is limited to the cases of litigation pending between your court and the Commission. So Rwanda wanted to expand Rule 50, which are not yet decided upon, and they have mentioned the case of lease Ali dependence. So we have tried to demonstrate that we cannot expand this provision to unsettled issues because your jurisprudence has indicated that there should be a decision based on the merits, and since there is no decision on the merits, and this was demonstrated this morning, we cannot plead on an issue of non-miscedents or res judicata. So in its pleading, Rwanda didn't dare to indicate the criteria that will establish duplicata, since they cannot rely on a decision that doesn't exist. So if we try to establish that this rule cannot be expanded, we have demonstrated with many arguments that even on the assumption that there will be a litis pendens situation, it will not apply to the case regarding our application, and based on the evidence we have mentioned today. To conclude, I would like to reply to the question put by Honorable Anuka, if I'm right. It is about the status of the pending case in front of the East African Community Court of Justice. So it is based on exceptional means raised by Rwanda, and Rwanda has raised no litis pendens objection. They have not raised any objection of abuse of rights or law. These are issues linked to the material, territorial, and temporal jurisdiction. So today they are deliberating and debating on this issue. And if we take the assumption that the ruling will be given or decided, there won't be any incidence or impact, and these two jurisdictions, the East African Community Court of Justice and this court, are not a similar jurisdiction of the same order, and they do not take the same measures. The measures requested or required under paragraph 29 of the amended application, I recall number 01 and 02 of the registrar file, under paragraph 29, under the requested measures, we cannot order them because we have to say that Rwanda has violated the treaties of the East African Community. On this, Mr. Vice President, honorable judges, I will conclude my response to your questions. You will make your final observations, and then you will be able to address this last point. You will have more time to address this point. Thank you very much. Now we give the floor to the respondent state for the final observations. Over to you. Have 30 minutes to answer. Thank you.
from satisfying the admissibility conditions therein merely because of the seriousness or the applicant's consideration of the seriousness of the allegations. If that were the case, Mr. Vice President, Honorable Justices, the court's legal framework would not have included admissibility conditions at all, since, as I have said, all human rights violations are serious. But indeed, the rules provided for admissibility conditions. Notably, the respondents or the applicant state spent quite some energy misinterpreting two communications from the African Commission, the Banjul Commission, being World Against Torture versus Zaire and Bernard Mona in the Bernard Mona case. In these cases, the Commission's pronouncement turned on the fact that remedies were, and I quote, as a practical matter unavailable or duly prolonged. They did not turn on the perceived seriousness of the allegations therein. In the Mona case, for example, the evidence of unavailability of local remedies followed from the fact that the Western Sahara situation had continued for many decades. The decision was not made based on the seriousness or perceived seriousness of the allegations. Similarly, while the Eastern DRC may be in civil strife, Rwanda is not. And we do not, of course, take that for granted. The local remedies that Article 6.2 of the Protocol and Articles 56.5 of the Charter and Rules 40, Paragraph 2 and 50, Paragraph 2e of the Rules of Court require the alleged victims to exhaust are ordinary local remedies in Rwanda, not remedies in the DRC. As we have exhaustively established in our written and oral submissions, Rwanda's judicial system is available, and it is available to all victims regardless of their nationality. And they are indeed functional, as we have demonstrated. Indeed, I agree with my friend, Professor Tresor Muhindo, nice to see you again. I agree with his interpretation of this court's jurisprudence that local remedies must be available and effective, both in theory and in practice. I certainly agree. Availability in theory refers to availability of the legal framework providing for or enabling the local judiciary to adjudicate over cases and to provide remedy. We have established beyond doubt that Rwanda has a robust legal framework in place for this purpose, and we have indeed cited specific laws and specific provisions. Availability in practice refers to lack of any impediment to victims in accessing these ordinary judicial remedies. We have similarly established, including by highlighting actual circumstances where Congolese victims have successfully pursued these remedies in Rwandan courts. And we've also established that these remedies are available in practice. Instead, the DRC simply makes assumptions and throws around a claim, which we take great exception to, that Congolese nationals would, I quote, be arrested or stopped from accessing courts in Rwanda, end quote. This, and with tremendous respect to my colleagues across the aisle, is unfounded. How does one establish that a remedy that is otherwise ordinarily available to all is not available to them in particular? And how does one know that these remedies are available or not in practice? The answer is rather simple, we submit. They attempt to access it. If the attempt is stopped or frustrated, then therein would lie proof that these remedies are indeed not available in practice. The DRC has not even once claimed that any Congolese victims were stopped or frustrated in their attempt to access Rwandan courts. Not even once. And again, what Article 6.2 of the Protocol, 56.5 of the Charter, and Rules 40, Paragraph 2, and 50, Paragraph 2e of the Rules of Court require is evidence that victims attempted to pursue these available remedies, but they were unable to successfully do so. The DRC has not produced any such evidence. At least we have not seen it. Additionally, just because Rwanda denies these allegations does not mean that its judiciary is precluded from adjudicating them. The Constitution and Law number 30 of 2018, as we previously stated, expressly grants the local judiciary, local courts, jurisdiction in this regard. As highlighted this morning, the legal framework in Rwanda allows victims, wherever they may be, in Rwanda or elsewhere, whether they be nationals of Rwanda or not, they do not have to physically be in Rwanda for them to access Rwandan courts. And we believe we've sufficiently established that. And lastly, permit me to address the ESCJ reference vis-à-vis the application before the court today, and just to hide a few points. It's a bit unfortunate, we believe, that the DRC has opted to evasively mischaracterize our submissions regarding the ESCJ reference, and that informs my brief, again, submission at the end. Instead of actually addressing these submissions, they've decided to evade them. To reiterate, our submission, which, of course, we made earlier this morning and which can be seen again in our written pleadings, paragraphs 147 to 168 of the preliminary objections and 156 to 172 of the rejoinder, is that filing two cases before the ESCJ and before this court that deal with substantially the same issues constitutes abuse of process. We have been hard-pressed to find any direct response from the respondents to this particular argument. Instead, they have evaded it. So let me reiterate quickly what the state of affairs is. The DRC has filed, the DRC has filed and maintains two cases, one at the ESCJ and one here in this court. That is a fact. Two, these cases involve the same parties, being the DRC as against Rwanda. And if I may read the heading or citation, the Minister of Justice of the Democratic Republic of the Congo versus the Attorney General of the Republic of Rwanda. That is the ESCJ reference. That is a fact. The human rights violations alleged before this court are also raised before the ESCJ. That is fact number 3. 4, this court undoubtedly has a human rights mandate. That too is a fact. And 5, the ESCJ has interpreted its mandate to include adjudication of human rights violations raised in the context of a reference before it, starting with its earlier decision in Katabazi. That, again, is a fact. And we have referred the court to several subsequent judgments of the ESCJ where the court has affirmed that particular position, and allow us to add at this stage that the ESCJ's 2015 decision in the Democratic Party versus the Secretary General of the East African Community and 4 others, that being Appeal number 1 of 2014, the Appellate Division of the ESCJ, in fact, held that that court, the ESCJ, has jurisdiction to interpret and apply the African Charter on Human and People's Rights. My good friend, I have many good friends, Professor Ezekiel Amani, again, nice to see you too again, has attempted to argue against the ESCJ's interpretation of its own jurisdiction. And he is indeed entitled to disagree with that court. I mean, after all, we owe it to our professional training as scholars to rigorously interrogate judicial decisions. However, the fact remains that the ESCJ considers its jurisdiction as including examining allegations of human rights violations arising from references before it. And that includes interpreting and applying the African Charter. We can speak about these matters till the sun goes down, and we suspect the court will not be happy with us. But what is apparent and remains unchanged is that what I've listed above in the last few minutes are undisputed and they are notorious facts. And perhaps that is why the DRC has not bothered to rebut them with any degree of seriousness. Mr. Vice President, Honorable Justices, thank you, and I would kindly request you to invite the Honorable Attorney General to close.
Mr. Vice President of this court, honorable members of this court, let me begin at the outset by profoundly appreciating how you patiently and at times tolerated us during these 2 days of our oral submissions. So thank you very much. And I'm saying this with first-hand experience of what it means to be on that side of this court. Mr. Vice President, Honorable Justices, this case represents a troubling attempt to undermine the procedural integrity of this institution. It is also a moment of heightened responsibility. As the first state-to-state dispute brought before the court, this case carries profound implications for the procedural and substantive standards that will govern future proceedings of this nature. Any leniency or deviation from these standards risks setting a dangerous precedent, undermining the court's legitimacy and its role as a guardian of human and people's rights in Africa. As our arguments conclude, let me take you to the court's website, very beautifully created website, in a section entitled The African Court in Brief. There, the court emphasized that its authority is built upon its unwavering commitment to the core values, amongst which I quote, judicial independence and impartiality as between all litigants, end of quote. Let me also quote again, I quote again, fair and impartial application of the African Charter, end of quote, and other relevant human rights instruments. The trust that African states place in this court depends fundamentally on its adherence to these core values, as well as on insistence on rigorous compliance with its rules and established procedural norms. This trust is not a given. It's normally earned and maintained by ensuring that all parties are held to the same exact standards, regardless of their motivations or the nature of their claims, and by applying the law as it is and stands today, not as a party may wish it to be. As with other courts, the integrity of this court's process is what ensures its continued relevance and authority in resolution of disputes across the continent. Hence, to compromise on these principles would risk not only the erosion of that trust, but also the diminution of the court's stature within the broader framework of international justice. This cannot be allowed to stand. African states, peoples, and individuals deserve nothing less than the highest standards of international justice, upheld with fairness, rigor, and also integrity. The respondent has, in the last 2 days, demonstrated that this application is not merely procedurally defective, but also substantively baseless. It fails to meet the most fundamental requirements of jurisdiction and admissibility, representing a clear disregard for the foundational principles of international adjudication. The applicant's actions constitute an orchestrated misuse of these court's mechanisms, evidenced by its procedural irregularities, failure to exhaust local remedies, and reliance on duplicative claims filed before another forum. Such conduct not only undermines the integrity of this proceeding, but also risks setting a precedent that encourages frivolous and at times abusive litigation practices within this institution. In other words, the applicant's case is, at its core, a poorly constructed attempt to overwhelm this court with procedural irregularities and excessive claims in the hope that something may stick. This honorable court has the duty and indeed the opportunity to reaffirm its commitment to rigorous procedural standards and the rule of law. We respectfully urge this court to dismiss this application in its entirety and to do so decisively. leaving no room for doubt that such tactics will find no quarter within these chambers. Finally, we respectfully remind the court, as it retires to consider these preliminary objections, that the court is considered to be bound by the application as it was filed, as matters stood as at 11th August 2023. It is telling in its oral submissions the applicant has heavily relied on matters which are alleged to have arisen since and after 11th August 2023. Any such subsequent matters are extraneous for the purposes of the court and should not, we submit, form part of its conclusion. Mr. Vice President, Honorable Justices, the Republic of Rwanda respectfully requests the court to adjudge and declare that A, the court has no jurisdiction to entertain the DRC's application because the matters contained therein fall outside the material and territorial jurisdiction of the court, and B, alternatively, and I stress the word alternatively, that the application is inadmissible for the following reasons. First, the application is incompatible with the Constitutive Act of the African Union. Second, the application is based primarily on news disseminated through the mass media. 3, the applicant has failed to exhaust local remedies. 4, the application deals with issues that have already been settled. 5, the applicant has failed to fulfill mandatory procedural conditions. And then finally, 6, the application is an abuse of process. Thank you very much for entertaining us today. Thank you.
L'État requérant, à vous la parole, s'il vous plaît.
Applicant, over to you, please. Honorable Vice President, Honorable Justices, I'm taking the floor this time in my capacity as an agent of the Democratic Republic of Congo, and through me, the Republic would like to thank you for the attention granted to us during this first stage, the preliminary stage of hearings dedicated to the issues of jurisdiction and admissibility. I have to admit that for me it was a honor and privilege to appear before you in such circumstances. Taking the floor, now I have the heavy duty to finalize this hearing in a very smooth way, and this is what I'm going to try to do. First of all, allow me to note very quickly that the distinguished colleagues who took the floor before me on the other side of the bar have mentioned a number of things, and namely the issue of accessibility of internal remedy, pretending that Rwanda has a system, a robust system of remedies. And they have also noted that the application before the ASG deals with the same issues in terms of merits together with the application before this court. As I said yesterday, we have to be very clear, and we should leave the judge the freedom to appreciate and assess the veracity of these pleadings. So I am not going to repeat so many arguments which were criticized and developed at large. But allow me to ask a few questions. These questions come to my mind right now while I was following attentively my colleague on the other side. If Rwanda has indeed robust local remedies, it means that they are accessible. If they're accessible, so imagine then that thousands of raped women and massacred people will have to introduce applications before Rwandan jurisdiction. We're not talking about one, only 2, 3, 5 victims. It means that those who have been displaced, who have nothing, no property, nothing, those who don't have houses, who don't know even where their children are, will say that this situation where we are have been created by the Rwandan troops, and let's ask this jurisdiction to condemn these actions and acts while they are facing humankind disasters. So the court will have the latitude to appreciate this question, and it means that such victims, at least those who are still alive, because most of them are dead now, should expect a fair trial. This is also an aspect to underline. Fair in terms of keeping with deadlines, of unbiasedness of the judges. Honorable President, we should be serious. The decision to invade the DRC decided by the governmental bodies of Rwanda and the judicial power is a real power in any modern state. So the prosecution in Rwanda have a relationship with the executive power. So how can I now prosecute generals? And this is how to have a fair trial. But it's not for 1 or 2 persons. It's for thousands of people. When we talk about facts, we do not speak about merits. We are very used to such procedures, but we have the duty to report things correctly and put them there in their context. We are not talking about one person. These are massacres, manslaughters. So the access to remedies, existing remedy, becomes impossible because people are dead and they have been buried in common tombs. So we have to take all this into account. Robust remedies, it means that for these deprived people who live in dramatic and terrible human conditions are going to fill all the judicial formalities and processes, pay the lawyers and so on and so forth. You can see how absurd is this issue. Second thing, the East African Court application is the same. No, in fact, it's not the same. We had the opportunity to exchange, to develop our prospects and points of views, and we mentioned here that we will appear, or we have appeared in front of the EACG to report that Rwanda has violated the human rights. And this treaty, as you will see, sets a number of principles of cooperation between member states, especially the interdiction of aggression or recourse to force and violation of territorial integrity. And my colleague has demonstrated to what extent the human rights assumption can be envisaged, and the protocol that should enable the court, based on other conditions different from this one, to examine some issues linked to human rights. And this protocol is not yet adopted. So how can we say that it is the same fact and the same causes. In our states, we can initiate different applications before different jurisdiction, commercial, penal, civil courts, and the officer is going to distinguish according to the material jurisdiction. This is the difference, Honorable President. So, at a given level, we should, and at this stage, we should say that there is a problem. There are theoretical abstractions, and this will not help us. It means that the court will refuse and deny justice if they don't judge. So those who were appearing before this court will not be able to appear before him without invoking the dependence. So they are trying to do everything to bar the way to the applicable judicial mechanisms which exist in modern civilization. Instead of advocating the systems of revenge dating back to ancient times, we're talking about jurisdiction, but the article is clear. The judge is competent within its jurisdiction. Honorable Vice President, honorable judges, you have to decide about your own jurisdiction, and you will really assess the jurisdiction. If you assess that you are competent, why shall we waver, and why are we insisting on such issues? In brief, Mr. Vice President, I have followed the agent of the Republic of Rwanda, and I said yesterday that regarding the merits, there are parallel convergences. Many things, because of their materiality, their material nature, or because or their configuration under which they are presented, are uniting us, importing things. When I followed the Minister of Justice of Rwanda, it is said that this procedure may be linked to an attempt against the integrity of the court. And he adds, and this is important, that the African people do not deserve less than other the benefit of such standards. Exactly. Exactly. This is what we will not understand, that the court is going to deny justice. So when it is victim of the violation of human rights, whatever the European Court of Human Rights states do not prevent the court from judging or exercising its jurisdiction to avoid this denial of justice. So now they are using some grounds, and now the African population will not understand it. The African population have to say that enough is enough, and we have to be aware that we cannot continue to perpetrate such acts indefinitely. We have to stop such massacres. Human lives are at stake, and the African population do not understand such situation. So you cannot say something and it's opposite. You are asking the court to behave in such a way that it has to ensure its credibility, but at the same time you ask the same court to behave, to use procedural grounds to escape its jurisdiction.
Minister of Justice of Rwanda urged the court to focus on its fundamental values. I took note of fundamental values, and I noted in this regard that it is Rwanda. Rwanda and DRC are two levels of different, and therefore adopt positions that are opposite. Rwanda is positioning itself as the one benefiting from the system establishing chaotic, tragic system of massacres. That is where it is positioning itself and want to benefit from consolation. Congo wants the establishment of harmony and ethnic balance. So we have to bring evidence to show that there is disorder. We're challenging the absence of normality. We cannot accept that people are being massacred in this manner. There is a breach in the social agreement, social contract, and the two different positions of understanding of two countries leads to two different positions. Congo is adopting the posture based on values. Honorable Minister, you talked about fundamental values. Honorable Vice President, as you do know, the forms are abstract. It puts emphasis on ideals, and that is in conformity with the Nazi regime, that when the regime attempted to sink humanity, the values and human rights are incarnated and linked to values. When we talk about human rights, you are talking about real things. We are not talking about abstract issues. We are not talking about pictures. We are talking about children who have lost their mothers, children who are not going to school, women that are amputated. We are talking about real issues. These are the essential values that we need for the courts, which we want the court to respect. Now, beyond this, there's a question that comes up. The right of human rights in Africa. If our own mechanisms are not able to sustain human rights. Yesterday, as well as this morning, when I was entering this courtroom, I saw some words on one of the posters close to a door that is for the honorable judges. It is the words of President Bembala of Algeria. The right to life is the first human right. End of quote. But for me, those who talk about human rights within the context of the African court, while challenging that massacres being committed should not be, we should not come before the judicial system. Honorable Vice President, honorable judges, practitioners, and international law and human rights, African wisdom and history of human civilization can sometimes prevent us from going into embarrassing, catastrophic situations like the one facing us now. We, representative of two states where the relationships are not good, and you as men, women, African men and women, who are called upon to arbitrate, to adjudicate on matters that have been caused by the dysfunctioning. There's this great historian who talked about the effects of war, and as part of this war, Honorable President, when the Greeks were fighting, the Greeks were often involved in war. There was a lot of pain, grief on the war front, and they realized that there was a manner of resolving the problems. Instead of we killing each other on the battlegrounds, let's leave the battlefield and let's come back to the amphitheaters. And away from violence, and back to the law. A law is born from the wish to move away from violence and to do away with violence, like what we are doing here, and solve problems to ensure that each one is given the opportunity to speak and talk about what he wanted to get through weapons. Your court will assist in de-dramatizing war. It is your mission as African men, African women, to contribute to the de-dramatization of war. Let's avoid falling into traps, the traps that are being set by our neighbors. For those who are doing what you are doing in this hall, international law, you remember that in the years 1930, a state geographically selected, Japan, brought continuous invasion on its neighbor Mansouri and created what was referred to as the ghost state of Manchukuo. And the balance of forces turned round. Those who were colonizers yesterday were no longer. Those who were conquistadors yesterday are no longer so. The major forces change. Imagine that you are not able to have a trial in this context where Rwanda is presenting itself in a way as to benefit, and to say that the court has no jurisdiction, the matter is inadmissible. 2, 3, 4, 5 years, it is the people of Congo that will find themselves in the same situation. And we will come back here, and what will the court tell us? That is why it is time for the court to the situation is dramatic, Honorable Vice, and we made the effort to position ourselves as professionals. We made an effort to respect your efforts, and we respect you, our colleagues on the other side. But among us, there are people who have left raped women. This is why the Democratic Republic of Congo believes in a civilized Africa, and this is why we want to come to such mechanisms. And by coming to the court, the DRC has demonstrated its commitment and conviction to the rule of law, or the primacy of the rule of law over the rule of force. The court is called upon as a jurisdiction to emphasize this primacy of law over the law of violence, and to reinforce the system of protection of human rights of law, and by ensuring the application of the African Charter on Human and People's Rights, and the promotion of Africa with a culture of human rights, a civilized Africa. And the exercise that DRC was involved in over these 2 years has demonstrated that we want the court to assert its jurisdiction so that Congo will be able to continue with the action that it has brought you before you. For DRC, it is important for the just cause to respect the normative framework established by the Charter and to efficiently exercising its jurisdiction. Honorable Vice President, honorable judges, let me conclude by appealing to you to find and hold that the application of DRC is admissible. Begin by saying that your court, to find and hold that your court has jurisdiction. All those the argument made from the other side, my distinguished brothers, are abstracts, diversions. We are lawyers. We know this how these things happen. So you adjudicate, Honorable Vice President, honorable judges. We have confidence in you, and we'll go through this stage. Not for vengeance, ours is not vengeance, but for peace and fraternity for present and future generation. Let me conclude by saying that you adjudicate this matter, you find that you have jurisdiction, and find that the DRC would like to reiterate its gratitude to you, and we submit ourselves to the force of law. Thank you. Parties for their final comments. 20th May 2025, and we thank all the parties for their participation in this public session. Respect for the directions given during our preliminary meeting, preparatory meeting. All the matters brought before the African Court, all the legal arguments are taken into account by the honorable judges present here. The court to deliberate. Therefore, the court to deliberate on this matter and reconvene on a date that will be communicated to you. And since we have exhausted the day's rule, the court is adjourned.